Judgment in the matter of X against the Lord Advocate.
Lord Burrows will explain the decision of the Court.
I should make clear at the outset that there is an anonymity order in place, that no one shall publish or reveal the name or address of the appellant or publish or reveal any information which will be likely to lead to the identification of the appellant in connection with these proceedings. Is the Crown vicariously liable for a civil wrong committed by a judge? That is the central issue in this Scottish appeal. A sheriff who in Scotland is a judicial office holder allegedly assaulted a female legal practitioner on 3 separate occasions. 2 of those were in the court building where he sat as a sheriff, and the 3rd was on a train. He also tried to contact her on her mobile phone. She brought proceedings against the sheriff, alleging that he was liable to pay damages in delict, the Scottish term for what English lawyers call tort, for the assaults, and taking the incidents together for harassment under the Protection from Harassment Act 1997. She also brought a claim against the Lord Advocate on the basis that the Crown is vicariously liable for the delicts of the sheriff. The sheriff has since been removed from office and he has taken no part in the appeal to this court, but it is important to make clear that he denies the allegations. They are assumed to be true for the purpose of deciding the points of law in issue, but whether the sheriff did commit those delicts has not been decided. The law on vicarious liability is the same in Scotland as it is in England. In very general terms, vicarious liability imposes a liability to pay damages on employers where their employees have committed a delict or a tort within the course of their employment. To be more precise, there are 2 stages to the vicarious liability inquiry. Stage 1 is concerned to establish whether there is an employment relationship or a relationship akin to employment between the wrongdoer and the alleged vicariously liable defender. Stage 2 is concerned with whether the delict or tort was so closely connected to what the wrongdoer was authorised to do that it can fairly and properly be regarded as done by the wrongdoer while acting in the course of the wrongdoer's employment or quasi-employment. On this appeal, Stage 2, dealing with the close connection test, is no longer in dispute. That is, it is accepted that the pursuer is not bound to fail on Stage 2. The appeal is therefore entirely concerned with Stage 1 of the vicarious liability inquiry. The outer house of the Court of Session held that she was not bound to fail at Stage 1, but that decision was overturned by the inner house of the Court of Session. The pursuer now appeals to the United Kingdom Supreme Court, arguing that she is not bound to fail at Stage 1 of the vicarious liability inquiry. The Supreme Court unanimously dismisses her appeal. The judgment is given by Lord Reid and myself, with whom Lord Hodge, Lord Briggs and Lady Simler agree. Prior to 1947, the Crown was immune from liability in delict or tort. But that immunity was largely removed by the Crown Proceedings Act 1947, Section 2. Section 2(1)A imposes liability on the Crown for the torts or delicts committed by its servants or agents. It's common ground that that means that the Crown can be vicariously liable. But the primary submission of counsel for the pursuer is that because a sheriff is a Crown servant, that subsection automatically means that there is the necessary relationship at Stage 1 of the vicarious liability inquiry. The Supreme Court rejects that primary argument. The correct interpretation of Section 2(1)A is that it imports the common law on vicarious liability. This means that because it's common ground that a sheriff is not an employee of the Crown with a contract of employment, the pursuer must establish that the relationship between the Crown and the sheriff is one that is akin to employment. So the whole question becomes, is the relationship between the Crown and the sheriff akin to employment? In order to answer that, the initial and difficult question is what is precisely meant by the Crown in this context. This essentially novel question has required the court to explore in depth the different meanings and capacities of the Crown by reference to a number of statutes and cases. In essence, the answer is that the Crown in this context means the sovereign acting in his official and not personal capacity, and the relevant official capacity here is that the sovereign is acting through the Scottish administration, and more specifically, that part of the Scottish administration that comprises the Scottish Government. Although no longer in dispute before this court, that explains why, applying the Crown Suit Scotland Act 1857, the lower courts were correct that the appropriate law officer to be sued was the Lord Advocate and not the Advocate General for Scotland. Ultimately, therefore, the relevant relationship for the purposes of deciding stage 1 of the vicarious liability inquiry is that between the Scottish Government and the sheriff. Is that relationship akin to employment? The answer is that it is not, for two compelling linked reasons. First, there is no control by the Scottish Government over the performance by sheriffs of their judicial functions. The judiciary itself determines listing matters, that is, where and when a sheriff sits and which cases he or she hears. In an extreme case, there is a statutory procedure for removal from office of a sheriff by the order of the First Minister as being unfit for office, but that requires a report from a specially convened tribunal. Secondly, and most crucially, it is a constitutional principle resting on the separation of powers that the judiciary is independent of government. That principle of judicial independence is enshrined in Section 3 of the Constitutional Reform Act 2005 and Section 1 of the Judiciary and Courts Scotland Act 2008. A sheriff must be free to decide a case, including cases where the Scottish Government is one of the parties, without any interference or the fear of interference by the Scottish Government. Those two linked reasons make clear that the relationship between a sheriff and the Scottish Government is, in a fundamental sense, not akin to employment. That is the case even though the Scottish Government, through the Scottish Consolidated Fund, may be said to be the ultimate funder of sheriffs' remuneration, allowances and pension benefits. The Supreme Court therefore agrees with the Inner House, essentially for the reasons given by Lord Doherty, that the relationship between a sheriff and the Scottish Government is not akin to employment. The pursuer is therefore bound to fail at stage 1 of the vicarious liability inquiry, so that the Crown is not vicariously liable for the alleged delicts of the sheriff. The pursuer's appeal is therefore dismissed.